Since this story posted last night and really, I think, changed everything in politics and in the lives of every American, not just women, the court has responded. And I have to start by asking you if you or Politico has been contacted by the marshals that Chief Justice John Roberts appointed to investigate the leak.
I'm not aware of anything like that. If it's happened, nobody's told me, and I think I would know. So not as of yet, Nicole.
Is there anything that you can or want to say about the commitment to protecting the sources on this story and the import of what you've published?
Well, I would say that when we published the story, we did what we could to try to preserve the source's anonymity as they requested, and we'll continue to try to do that. And, you know, the Supreme Court will proceed as they see fit. And, you know, we stand by our story. We think it was accurate. And indeed, the key part, I think, of the statement that the Chief Justice issued today is he said that this draft is authentic. So you have on the record from the Supreme Court that this is in fact an actual draft opinion that at least at some point has been under deliberation there among the 9 justices in their private conferences.
It is literally the highest level confirmation a journalist with a byline on the story could possibly have. So I want to turn to what you've reported, and I want to read some from the original story, just to reset. I know there's not many who haven't seen it, but let me come back to the reporting. Alito's use of the phrase in the draft opinion, egregiously wrong to describe Roe, echoes language Mississippi Solicitor General Scott Stewart used in December in defending his state's ban on abortions after 15 weeks of pregnancy. The phrase was also contained in an opinion Brett Kavanaugh wrote as part of a 2020 ruling that jury convictions in criminal cases must be unanimous. In that opinion, Kavanaugh labeled 2 well-known Supreme Court decisions, quote, egregiously wrong when decided. The 1944 ruling upholding the detention of Japanese Americans during World War II, and the 1896 decision that blessed racial segregation under the rule separate but equal, Plessy versus Ferguson. Just pull this thread a little more for our viewers in helping us understand the significance of Alito's phrase, egregiously wrong.
Well, what he's trying to do in this opinion, and part of the reason that I think it is so forceful and so brutal in its assault on the Roe v. Wade precedent, is he's trying to build up a head of steam here to say that this isn't just a precedent that was wrong. This is a precedent that the court got so terribly, and in his word, egregiously wrong, that we should disregard the usual policy of respecting precedents and throw it out the window. And what is very interesting about this Alito opinion, and I think probably challenging to a lot of people who read it, is, you know, he's drawing a direct line to Plessy versus Ferguson. He's essentially saying Roe v. Wade was as wrong as the decision that said that segregation, legal segregation, could be carried on between the races in the United States. And so why is he doing that? Again, it's because he has to show this opinion from 1973 to be so hopelessly flawed that the justices shouldn't take any concern or be particularly worried about the fact that by overruling it and overturning it, they're defying the usual principle that the lawyers call stare decisis, that once a case is decided, that precedent should remain on the books absent extraordinary circumstances. So that's part of why this decision is so withering. And, you know, it could be, if our reporting is correct on this, could be why Chief Justice John Roberts does not seem to have given his assent to this type of a frontal attack on Roe.
Did Alito mention Plessy versus Ferguson in his confirmation hearings when he was asked about Roe?
I don't know that off the top of my head, Nicole.
He did not. I think you know, none of them made this legal argument. And I guess my question for you, knowing these folks, is where does this come from? Because I think that when Justice Sotomayor described the stench of what the legislature did by writing their ban on abortion after the Trump nominees were confirmed, she was talking about this intersection of politics and the court. And I wonder where this analysis of Roe to Plessy comes from? Does it exist in far-right legal writings or websites? I mean, have you ever heard that before?
Yeah, I do think that it has been the subject of other opinions from the court, dissenting opinions in abortion cases. And the reason that you kind of have to grapple with it is the point is that Plessy versus Ferguson was overturned by the U.S. Supreme Court in Brown versus Board of Education in 1954. And so they're trying to find examples where the court has taken something that was very well established for a period of years, of decades really, and has tossed it. And, there are examples of it. There aren't that many examples that involve principles that affected the lives of every American or many, many millions of Americans. And so they're looking for those examples. And this is one that they seize on in this particular opinion. And is this exactly what may have been of concern to Roberts? I don't know. Is it something we're likely to hear more about in the dissents we expect from the Democratic appointees on the court? I certainly think you will.
Josh, you're 20 hours into, or about 19 and a half hours into this bombshell reporting. What are your views? I mean, do you have any additional insights? What has the reaction been from sort of sources close to the justices themselves to the report?
Well, there are different camps, Nicole, about what is going to happen here. I mean, the issue is that since this hasn't happened before, it's very difficult to say. The justices, this is regarded, I think, probably by many of them as a breach of trust. But what is the impact on those deliberations that take place in that private conference room with only 9 of them there? Are they pointing the finger at each other? Are they pointing the finger at other members of the court staff? Do they blame each other for what happened? And the most interesting dynamic here, I think, is, there is sometimes some horse trading, some exchange of opinions and some change of votes and some toning down and perhaps sharpening of opinions. Usually happens right in this period we're going into right now, according to the former clerks and so forth that I've talked to. It happens in May and June. That's why these opinions take until the end of June in the controversial cases to be released. And will this draft opinion coming out impact that by causing some justices to stiffen their spines and say, I'm not moving from the position I've staked out earlier because I won't be intimidated by any sort of public report? Or will the public reaction to this lead to different views from different justices? Will the whole controversy lead the court to come together in some fashion? A lot of people think these justices are so set in their views at this point that nothing could sway them. But I guess we're going to find out in the next 8 weeks.
And the draft seems to characterize public opinion as extraneous, which is so contradictory to the public pronouncements by the Chief Justice, by retiring Justice Breyer, by Amy Coney Barrett and others about their deep and sincere malaise that the public no longer trusts the United States Supreme Court in the kind of numbers it did just 22 years ago in the wake of Bush v. Gore. What is does that divide the court as well, that Alito is so brazenly disdainful of public opinion or where the country is on any issue? And a majority of Americans are against overturning Roe. There are divisive opinions within abortion technically, but not on Roe versus Wade. What is Alito saying in that part of the opinion about the need to disregard and view as irrelevant and radical public opinion?
Right. So he's saying, we should call it as we see it based on strictly the law, and we shouldn't consider how the public will respond. He also dismisses what the court and especially Chief Justice John Roberts has said in the past are things that are very important to him, which sounds pretty arcane. They use the phrase reliance interests. And what they really mean there is, in this case, that you've had tens of millions of women come to rely on the availability of abortion over the last 50 years, that they could count on that as a federal constitutional right, even though it's been cut back, somewhat over the last couple of decades. And so both those things are sort of rejected out of hand by Alito in this opinion. And frankly, it's one of the factors that led us to confirm our reporting that Roberts is not on board here. When you look at some of the language there about the court's reputation, public reaction, saying things like, well, we can't predict how the public will react and we shouldn't take that into account. Roberts has said things almost directly contrary to that. And so it's very difficult to see if that kind of language remained in the opinion, how he could stay on board. I also think just in terms of tone, the way the opinion treats Roe versus Wade and implicitly the justices who signed on to that opinion in 1973, again, doesn't sound like the degree of respect that Roberts typically pays to other members of the court and what he views as decorum. But, we shall see. Does that language remain in the opinion? Does Roberts write separately? And does he formally dissent from those parts of the opinion? Are all things that not only I'm looking for, but a lot of court watchers are waiting to see with bated breath at this point.